The proceeding will start.
Order. Welcome to the Public Accounts Committee on Monday, the 25th of March, 2024. Today we're looking at legal aid and what value for money the state is achieving from this. The government has a duty to fund legal advice for the most vulnerable in society, and the Legal Aid Sentencing and Punishment of Offenders Act, or LASPO as it's often colloquially referred to, was implemented in 2013, and this significantly reduced the scope of legal aid in England and Wales, and this committee looked at that back in 2015, and we felt concerned then that there were many areas that did not at the time have access to legal aid, but also that there was a concern we raised in that report that we published at the time that there wasn't enough interest in the MOJ about the knock-on costs of its reforms across the public sector, but also to other parts of the system. So we have another National Audit Office report looking at this, which we're examining today. And so we're keen to hear from our witnesses how they think legal aid is going and whether it's achieving the value for money that is intended. I'd like to particularly on record my thanks to all those who've submitted evidence. We had a really useful slew of evidence from various contributors, so thank you to them for that. And before I introduce our witnesses, I just would like to see if there are any declarations of interest. I think Sir Bob Neal would like to say something.
Just for the record, I'm a non-practising barrister and a former consultant to a law firm.
And Sir Bob, of course, is guesting on this committee today as chair of our sister committee, the Justice Select Committee. So very warm welcome to Sir Bob. Our witnesses today are the Permanent Secretary from the Ministry of Justice, Antonia Romeo. Welcome back to you. She's joined by Jane Harbottle, who's the Chief Executive Officer of the Legal Aid Agency, first-time witness at the committee. And Jerome is the Director General for Policy and Strategy at the Ministry of Justice, or rather for the Policy and Strategy Group. Titles seem to keep changing. And Latham is the Development Director at His Majesty's Courts and Tribunals Service. So a warm welcome to you all. Before we go into the main session, I just wanted to pick up on some issues around court reform, if I may, with the Permanent Secretary. You wrote to us Nick Goodwin from the Chief Executive of His Majesty's Courts and Tribunals Service wrote to us in late February about some changes to the programme there. And one of the ones that was most concerning was that the implications for the functionality and user experience for staff of not going ahead with phases 2 and 3 of the common platform was something he raises. He wrote to us about. But what are those implications if you're now axing phases 2 and 3 of the common platform?
Well, so first of all, thank you for having us today. The purpose of the reset, the following which the letter has come to you, was to actually essentially rescope some areas, including on the common platform, where it was felt most appropriate to do so, largely in response to feedback from staff and users. So in practice, for example, the plan had been to roll out the common platform throughout all Crown Courts, and to use that also, as it were, as the kind of top-level portal. We're now going to be using the digital case system as the thing that sits on top of the common platform, which users already know. It's been in place since, I think, 2016. Jason will correct me if that's not quite right. So the idea was we had a lot of feedback, and you'll recall at previous sessions in front of this committee, we haven't necessarily always, throughout the programme, listened to feedback enough. So this is a specific response to some of the feedback to try and improve the service for users and of the system, and to ensure that we didn't lose the functionality, but we actually made it easier to use, and we also weren't trying to roll out yet another change for the users when there's already quite a lot of change happening in the Crown Courts.
But they're just not going to go ahead at all now, phases 2 and 3. That's what the letter said.
I mean, Jason might want to talk about some of the detail, but the kind of last mile, if you like, is actually we're not going to go ahead in the way we had envisaged it. Instead, people are going to be using the digital case system. What that means is instead of replacing it with the common platform, we'll have to be doing additional work to manage the interface between the digital case system and the common platform. So there's different types of work so that you get the same outcome, but you're not replacing it in the same way as had originally been envisaged.
Maybe Ms. Latham can help. Was there a procurement is there going to be a procurement process for the new work that's going to have to take place to patch those two systems together?
So the digital case system has been in place since circa 2016. The functionality in releases 2 and 3 were intended to kind of provide the same functionality but within common platform. We've decided to de-scope it so we can concentrate on stabilising the system and responding to change requests from staff. The courts are well versed in using the digital case system. The judges are very supportive of the approach that we've taken. There will be further work to look at how we can integrate it further so that it works more automatically with the common platform. But to intents and purposes, the digital case system has been working with the common platform during the whole of the rollout of the common platform system across the Crown Courts.
So you're stopping doing something, but what's replacing it is already working, is what you're saying?
Yes, basically it's working very well. The judges are very supportive of it, as are other users. So we decided to refocus efforts on change requests coming from staff and fixing some of the technical defects in the common platform system so it can work faster and slicker for our staff.
Okay, and what about the value of the benefits of the programme, Ms. Romeo? Have they been reduced as a result of this change?
Well, yes. I mean, there's as you'll know, the overall cost of the programme hasn't changed since the 2021 business case, or that has slipped to the right. Inevitably, the slippage of benefits to the right means that the value is brought in less quickly. Also, one of the other things that we're going to be looking at is the extent to which, obviously, a lot of the value comes from essentially automating.
Yep.
A lot of that, well, some of that will not be captured in the same way. We won't be getting the same value because we won't be automating to the extent, and we're still working out now what it means in terms of actual benefit delivery over the next year.
So just to be clear, it has now been descoped officially. There's no plans to go for that all singing, all dancing approach that was proposed.
That's correct.
Originally. And that's now the settled position.
That is the position as signed off by the Lord Chancellor, the Lady Chief Justice, yes.
Okay, well, we'll leave it there for now because I know our sister committee no doubt will be coming back to this, and we may well do in future as well. So thank you for that for now. So we move into our main session, and we're looking at access to the value for money from legal aid. But one of the things I wanted to start off with was really looking at the access to legal aid, particularly geographically, so to start with that. The procurement areas for legal aid have been expanded over the years, so that can mask the ability of people to access it. And there's some useful maps in the National Audit Office report on pages 36 and 37, which give an example of the challenges available. But why was the decision made, Ms. Romeo, to enlarge the procurement areas for legal aid? And were you aware of the risks of doing that?
Well, so I think you're talking about civil legal aid, are you?
Yes, sorry,
so, I mean, obviously, we have set, by and large, the basic design of the procurement areas has stayed the same since 2010. And where we've made changes, we have made them to align, to basically make the thing more effective. So, for example, in family procurement areas, these were changed in 2018 when HMCTS rationalised the London family courts in 3 locations. So we then aligned the legal aid procurement areas with those. So broadly, and Jane can give more detail on exactly how the areas align and which legal aid areas align with what, but obviously it's quite different depending on you're thinking about criminal or civil or family. So we're always trying to do the smartest way of alignment, because you'd want to align as much as possible. If there's rationalisation in one area, then we would rationalise the legal aid procurement areas as well. But I don't think it has triggered a particular problem. I mean, change always creates some risk, but we're doing it, we see it as an improvement to do that alignment, not as something that just generates risk with no benefit.
Okay, well, Ms. Harbottle, doesn't it mask large gaps in provision because the areas are so big?
Okay, I mean, thank you for inviting me to the committee today. I would say that our current model actually relies on a vast range of private practitioners and not-for-profit sector who want to do legal aid work. And I think it's right in more broader terms that the report highlights that we don't compel people to do work through their contract. However, we don't place any limits on the number of people who can have a contract. So as long as they meet the quality requirements, then they effectively get a licence to do and carry out legal aid work in the localities that they wish. As the Permanent Secretary said, our procurement areas largely were devised in 2010, so that was slightly before LASBO. And the general considerations, of course, at the time, and we keep these under review, are that where possible, services should be delivered locally. I mean, that is where possible. But we then need to balance sufficient work volumes with access to a quality service. And then, as the Permanent Secretary said, we do align the procurement areas with other associated services. So, I mean, if I can give you a little bit more detail.
Give us a specific example. Just
so say, for example, mental health procurement areas were amended in 2014, and that was when the NHS moved away from the former strategic health authorities. Community care in the past was very aligned with social welfare law, which was a huge category of law, most of which was taken out of scope as part of LASBO. So there was lots of integrated services and coupling at the time of community care with those services. Obviously, once that was taken out of scope, we reviewed the community care boundaries, and we decided actually the volumes of work meant they were more akin to things like lower volume categories like public law, claims against public authorities, and clinical negligence. So we reduced the number of access points and the procurement areas then. And then probably the other important one, I think, is criminal legal aid, because obviously criminal legal aid and access to criminal legal aid is based around what the police tell us they need to have, you know, enough providers in their custody suites day to day, and also what the magistrates need to have on the ground to deal with court duty matters each and every day. So they inform us, we work locally with those entities, and then we produce the duty solicitor rotas that service the police stations and service the courts.
Okay, so there's a difference there, isn't it, with criminal, where you need to really see someone face to face. If you're in a cell, at that point the duty solicitor would have to be available.
Yes, so they are available. They will get a call. The police will call a duty solicitor call centre, and that will be deployed to
so that's
the
quite a
duty
different
solicitor.
service that people are providing, and which needs to be geographically spread across a wider procurement area. Are you confident that you're getting that geographical spread across the large procurement areas?
Yeah, so by and large, for criminal legal aid, so we start with criminal legal aid, by and large, all the duty solicitor requests, all the sort of slots that are requested are covered. That is not to say we see pressure in more of the sort of rural areas where perhaps the sort of volumes of work aren't there. We also have two schemes which are being covered through adjoining solicitors in different procurement areas. So I'll give an example of Skegness, for example. So there's no magistrates court there, but there is a police station there, and providers in Lincolnshire are helping to cover that scheme. And where we do see gaps like that, then obviously we're in close contact with Jerome and the policy team to see what the sort of longer term options may be on those schemes. And in fact, we've just filled a similar issue that we had in Llanelli in Wales by working with Jerome's team and agreeing with ministers that we would take a different approach which made that scheme still viable for a particular provider.
Because in the past when we've looked at this, there have been big gaps in areas, and now the procurement areas are bigger. So the concern is that you can have a lot of providers in a procurement area. They could be weighted to one area. So you've given the example of Skegness where there's a gap and what you're trying to do there. But how many other areas are you aware of from the centre, and we'll come into this in a bit more detail in a moment, but have got gaps? And I might ask some colleagues to come in.
Yeah, okay. So there are 134 procurement areas in total across the country, and I think the map in the report shows housing and debt. So there's 134 of those, and we currently have 9 areas with no face-to-face advice. There are 105 what we call helper schemes, and this is a new initiative which has been in place since August 23, and this is for anybody, and Jerome may want to say a little bit more about the helper scheme, but effectively anybody can get social welfare law advice, pre-possession hearings, and on-the-day court advice in their local county court. Now, we have a gap in 2 areas on the Hill Pass schemes, so that is Wigan and Crewe, and they have no on-the-day court advice. However, those individuals can also seek remote advice through other providers or through providers in neighbouring areas. I've covered the...
How do they know that they can get that other advice? If they can't find advice locally, how do they know they can get it remotely?
So specifically in Wigan and Crewe, we've done a lot of engagement with the local courts in those particular areas, so that the core staff are aware that clients can seek early legal advice when they turn up on the particular day. We also have our telephone service, which provides remote advice, and that is well established and well advertised on the back of the court information and documentation as well.
On the geographical disparities, I'm going to come to Mr. Matt Warman.
Thank you. By happy coincidence, the example you mentioned is in my constituency. But if you look at the maps on Figure 9, then both in terms of the distance and the increase in distance, then a constituency like Boston and Skegness is as dark as it can get when dark is bad. You mentioned that project to fill in a specific gap, but I just wonder how aware you are of other equivalent gaps, because that's one service rather than all of them. And when you consider how urgent it is to fix those gaps, how much do you consider when it comes to the remoteness and the suggestion that they could do it online? How much do you consider the vulnerability of constituents, and how much do you consider the provision of broadband itself?
So the first question was you just repeat the first part for me. I only got the vulnerable bit.
So where you talked about filling in a gap in one service, as in the example that you gave, how long were you aware of that gap being there, and what about the other gaps in other equivalent services where there isn't an easy fix?
Okay, so across the country, every single legal aid provider has a local contract manager. The contract manager's function is to provide a degree of assurance against the contract. They meet in the sort of measures that we set out, but also to understand the provider's sort of longer-term business plans, any challenges that they're facing on the ground, any local intelligence from, say, other CJS partners or wider partners in that particular locality. They also, of course, take intelligence from the providers themselves and what they're seeing in their own particular office. And all of that sort of intelligence is fed back to our commissioning team, because the main sort of levers we have as the agency, obviously it's ministers who are responsible for setting legal aid fees, etc., as I'm sure most of you know, but the main levers we have is to instigate a new tender in that particular area. Or we may look at neighbouring schemes, and we will consult and engage with the providers in those neighbouring schemes to see if they feel they can cover that particular work. And if they can, then great. If not, then clearly we need to escalate that to policy colleagues as well, or utilise, maybe in crime, the public defender service to do that.
But I'm thinking, ultimately, how bad does it have to get for you to trigger that kind of process? Could you give us a flavour of what that might mean in practice?
So in Skegness, we knew we were going to lose the provider, so we proactively engaged with the providers in the neighbouring schemes to ensure that all the duty rota slots were covered. So we haven't lost any duty slots. If you're talking about crime, we haven't lost any of those.
But you will have people travelling further afield. I mean, Lincoln's just quite big.
Yes, people will be travelling further afield, and that is something that obviously I can't change the payments for travel. They are set in the regulations, so we do have to get the agreement of the local or the nearest scheme area, or that is where obviously we feed that intelligence back into policy colleagues, and obviously some of that was picked up as part of the criminal legal aid review, which Jerome might want to talk about a little bit more as well.
I just wonder how typical that ability to step in before something falls over is nationwide.
Well, so far we haven't had any gaps, and we are constantly monitoring the market. It's particularly relevant, as I said before, to keep our finger on the pulse in the more rural areas. So Barnstaple is another example.
Mr. Glass.
Might I just come in? Sorry, I appreciate you're asking a local question, but can I make just a sort of a national point, which is that, as Jane was saying, when we are aware of these sorts of problems, what we do is we look at the fee schemes, and we have obviously, and will come on to this, just reviewed the criminal legal aid schemes, and we have uplifted those schemes by 15% overall. And in particular, what we've done just recently, indeed in January of this year, is launch a consultation on the kind of the crime lower, so basically magistrates and police station scheme, where what we're trying to do is uplift, again, the police station schemes in particular, because that's where we're aware, as Jane was saying, we're aware that there's a problem. So they won't just be getting a 15% increase subject to consultation, they'll be getting a 30% increase in fees.
You only have to look at the map to see that although it is on one level a local question, there are a lot of local examples.
Yeah. Yes, exactly. And what about the cost of travel, Mr. Glass? Is that something that is obviously laid out? So is there any prospect of changing that? Because it's, you see, you've got a choice with your local area or travelling to Skegness. Yeah. It's no brainer that if they're trying to look at their bottom line, that they would look at staying in the local area if they had a choice, a binary choice of the two on any particular night in question.
So that's not something that we're looking at in the context of the criminal schemes, although it is something that we have done just recently on the immigration schemes.
We're going to come to that. Yeah.
Okay.
So you're not looking at it for criminal. So you're monitoring to see if there's have you done any modelling to see if there's someone in Skegness in a police cell needs a duty solicitor and someone in another part of Lincolnshire needs a duty solicitor, which one would get the covering provided?
Yeah, so all the calls go through to the duty solicitor call centre, and those calls must be deployed in a timely manner, and then as part of our contract requirements, first contact must be made with the client within the first 45 minutes. Now that could just be a quick telephone call, and then obviously they need to attend when the police are ready to interview. That scheme is interesting because we were actually, with the Lincolnshire providers, we did initially agree that they just worked as a sort of backup system, if you like, and were sort of on call because obviously some of the work is quite seasonal, I think, in that particular area. But what they said was to help with their business planning, they preferred to be rotated onto specific slots at specific days so they could work out what was the best sort of way of covering the Skegness scheme as well as their other duty schemes.
That's partly how you get around it because they're rotated on. So, okay. So you're listening to provide. Okay, I wanted to go on to immigration advice because as a result of the Illegal Migration Act, you did put up fees by 15% for areas covered by that to attract providers. Can I just check? I don't know, Mr. Glass or Ms. Romeo, is that coming from the main LASPO budget?
No, because of course this is the consequence of Home Office departmental policy, so we'd expect the money to be delivered in the usual way for the downstream department.
So it will be transferred from the Home Office. The Home Office will fund that completely, the whole 15%.
Yes, I mean I don't know where the original source of the money will come from, but yes, we're expecting to be given.
Okay, so it's not basically my question was it's not
crowding out other funding.
Okay,
that's right.
Okay, and so and has that worked? Has that been attracting providers?
Yeah, it has.
Mr. Glass.
So yes, I mean obviously the Illegal Migration Act has not yet been implemented, and so we haven't yet seen the work come through. But certainly from our initial engagement, there was a very strong sense from the sector, and we did a lot of engagement in the run-up while we were just designing this. There was a very strong sense from the sector that is what would help in order to make sure that there was sufficient provision for the increased amount of work that we were expecting under the Illegal Migration Act.
When the tap's going to turn on, because obviously, as you say, the bill's not been yet. It's not been implemented yet. Yeah. So when will you've obviously got to work with providers before that point. So you've had some engagement. Can you just talk us through where that engagement's got to, what the take it will be, and whether there will be deserts when there's been a long time that there's been desert areas for immigration advice in this country. So parts of Wales you couldn't find an immigration lawyer 14 years ago. I think it's much the same now. Looking at the maps, how are you going to make sure you fill those gaps? How far have you got with the people that you're already engaging with?
I guess two things there. So firstly, Jane might want to talk about specific areas of the country where we know that that there are issues with immigration provision, which I think is particularly in the southwest. That said, overall, actually, what we found was, and again, this is largely sort of Jane's contract running procurements, but we found that we have actually kind of increased, we've seen an increase in the number of providers over the last year, particularly for immigration, and so we are sort of relatively confident that not only through this procurement and also through the increase in the fees that we will have the coverage. Of course, That is dependent on the numbers, but so far in terms of the modelling that we've been doing with the Home Office, we are reasonably confident that the 15% plus the additional procurement we've done will mean that we should have coverage. I don't know if Jane wants to pick up on the South West particularly.
A couple of things. So we currently have a live tender out, advertised at the moment. So early indications are we are getting a good response to that, but clearly it's early days and I can't really sort of go into the individual numbers. We did open up the tender to civil providers in 2023. As a result of that, we had an additional 100 providers wanting to do work in different categories of law across 216 officers. 40 of those providers were immigration, and we also got an additional 7 providers to cover work in the IRCs, the immigration removal centres as well. And as I said, the sort of tender that's out there at the moment, we're seeing a sort of fairly healthy response, but that needs to work its way through and we need to verify all the information, etc. In the Southwest specifically, so we have 7 immigration providers. We were notified...
when you say the Southwest, can you just give, so people who are listening know the geographical spread, presumably across Cornwall to Devon?
Cornwall, sort of Bristol area, Devon. So we have we have 7 currently. A large provider, though, withdrew their services not too long ago, and the existing providers told us that they were struggling with capacity. So what we have done is essentially, I suppose, for want of a better word, launched a matching service, if you like. So those providers who are at capacity will refer to another list of 31 providers we've secured across the country who have indicated they do have capacity to take on work from the Southwest.
That means remote.
Yes, that does mean remote, albeit the providers in those areas in the Southwest will hopefully be prioritising sort of people who really need face-to-face and then referring people remotely. So it does indicate that we have a sort of healthy interest in sort of doing this work, but there is a slight sort of mismatch in terms of where some of the providers and where some of the providers are choosing to base themselves and the amount of work coming through.
It's quite a significant issue, which a colleague will come to further. Mr. Glass.
If I could add just a couple of other things that we've done in order to, so you asked about where we are with the providers. One of the most positive things we've done, for example, recently, is we've agreed a contract with the Law Society where we're paying £1.4 million to meet the costs of accreditation for new immigration asylum lawyers. So again, that's us trying to kind of build the market, because we heard from them that there was a particular issue at the kind of trainee contracts, etc. So it's trying to kind of pay for that on
that's the MOJ's paying for that.
Sorry, that is the same funding that the Permanent
Office.
Secretary was talking about. So it is.
Just my final question before I turn to Sir Bob Neal. In terms of the funding of the Home Office is going to be providing, is there a cap on it, or how is that? Is it because it could be a lot of money, but is there any point where that tap runs dry?
Well, they'll be. Essentially, they are funding the downstream consequences of their policy. Yeah. So we've given them our estimates of what we think the amounts would be, and we'll be kind of watching and seeing. There's only so much in practice. It'll all depend on their assumptions. Yeah. As in terms of the volumes, and we can apply our algorithm to those and then give them back that.
Just to be clear, the MOJ is not on the hook for any of this, whatever happens. Your modelling isn't. They're not going to hold you to your modelling and say, well, you told us this much and it's more, and you now have to pick it up. Just to be clear, it's all through the Home Office, or through the Tribunals.
Well, obviously we work very collaboratively with them. One and two,
I'm sure you're collaborative, but
we're happy to do our bit. Yeah. But in terms of the budget, the estimates of how much it's going to cost depends crucially on things like volumes and flows into the system, about which they're the experts.
In accounting terms, this will be in the Home Office accounts, and it will be in your accounts too as receipts from the Home Office spent on...
In accounting terms, the accounting officer, as it were, the principal accounting officer for everything that flows from the Legal Migration Bill is the Permanent Secretary of the Home Office. Obviously, there'll be some things like appropriate spend once it's out and in our budget would be Jane as accounting officer and me as PAO of that bit of the spend. But the dependency on the volumes and things that flow in, that is held elsewhere.
Okay, it's just that we want to follow through where the money goes and how it's spent. So will we need to look at both sets of accounts for us to understand how it's
Well,
spent?
I think you would. I mean, we will definitely be spending some of it, so you might want to look at our accounts. But the agreement at the outset of the policy was the Perm Sec of the Home Office was essentially the accounting officer for the spend associated with this Home Office policy.
Okay, well, we're looking at some of these costs, not directly on legal aid, but in 2 or 3 weeks' time. Okay, I'll now move to Sir Bob Neal. Sir Bob, welcome.
Ms. Romeo, your predecessor, Sir Richard Heaton, expressed the view that he wanted the Ministry of Justice to be the most data-driven department in government. How far have we got along that track?
Well, you'll have heard me say similar things to Bob when in front of both, in fact, this committee and your committee.
I'd just be interested in your take to this committee.
I think we've got, quite far in different areas. So just moving off legal aid for a minute, we've done quite a lot in terms of joining up data under things like the BOLD scheme, which is joining up data across the whole of the criminal justice system. That sort of thing is essential to be able to track flows through the system, offenders, etc. I have also recently appointed a Director General to lead on our service transformation, which is going to crucially look at using data and digital as a way of how we can actually digitise our services. As you know, we've got a large number of services that we wouldn't consider to be, truly modern at the moment, and so that process is in train, and I'm quite ambitious about it, but as we've already heard in a way relating to the HMCTS reform programme, being too ambitious at the outset with the speed at which you can transform things digitally is unwise.
Can we bring specifically back to what data is held around legal aid, for example?
Right.
We've heard about gaps. What data do you hold that indicates why those gaps exist? And who holds it? Is it the ministry or is it the agencies? Is it the legal aid agency? Is it HMCTS or what?
Well, all the above in a way. So I'll say, let me say some things about the overall data picture. So obviously there's data on large numbers of things because we collect data on the consequence. We can come on to the consequences of LASPO, what happened on scope, what happens on eligibility.
I'm interested at the moment in the position around access to justice points. Legal aid was taken out of scope in a lot of areas. For example, does anybody in the ministry or its agencies, Mr. Harbottle might be able to help us to what data do you collect as the distance people may now have to travel to get face-to-face legal advice? What data do you collect on the distance that a duty solicitor may have to travel to do a call at a police station? What distance they may have to travel to the nearest available court? How do you collect that? That must be important.
Okay, so if I've talked more broadly about data.
How do you collect it for a start?
So,
do you?
So in the agency, we will collect data at the point at which a client is eligible for legal aid, or a provider opens a new matter start, or a provider bills us for payment.
Got that, but I was asking you specific questions.
But
can you answer those specific points, please?
In relation to distance travel.
Distance travel, for example, yes. How much longer is Mr. Warman's constituent going to have to go? How much longer would that duty solicitor have to go? How much further would have to go for a court hearing? They're very specific. You must have data on that, surely.
We would map data and get the data where we saw a particular gap in
You don't do it
services,
routinely,
like
then?
in Skegness and Lincoln. We don't do it routinely. We look at we monitor the number of contracts we have against against the procurement areas that we set ourselves, and we look at the provision and the number of contracts in each of those particular procurement areas.
Can I just add something, perhaps, more briefly? We're very careful to not to put too much of a burden on the providers. So a sort of giant data request to all the providers that says, how are you finding this, that and the other, we've got to be a bit careful about. So this is broadly done within the work that the Legal Aid Agency are doing and monitoring provision.
But you will want to know, but you'll surely want to know those anyway to know the impact of your policies.
Well, we're ensuring that we've got provision, and Jane's monitoring, exits as described.
Yeah, but that's missing the point,
provision.
isn't it? It's not about the provision; it's about the impact of the policy. What do you collect on that?
Is it? Do you? I'm very interested. Do you think that it's the case that providers would welcome us asking them for a lot of information about how they would have to provide to us? Because Jane's trying to collect the data at a sort of overall level rather than go to...
Lots of them were collected anyway. mileage and time...
They'll be putting in their claim forms, for example.
Well, indeed. So therefore, that is collected, though. If they're already providing it... Well, they're providing it to the Legal Aid Agency.
I mean, we have data sets on, the time taken or travel taken, etc., and all of that is used for, to help inform policy decisions and policy making.
So what do you do then, Mr. Glass, when you get all this data?
Well, that, as I was explaining earlier, that's part of the backdrop to when we look at all the various options available to us, be it fees, be it changing scope, and all that sort of stuff. And so that data fed into the post-implementation review for LASPO. It's part of the analytical annex to the Criminal Legal Aid Independent Review. It feeds into how we design the Hill Pass scheme. It's going to feed in really critically, and sorry, this is an important point, it's going to feed into the review of civil legal aid, where we have done a provider survey, specifically on asking providers exactly, what their views are on the future provision. So it's all part of the picture for how we design the policy. We do, it's worth saying, we do have pretty good, in fact, we've got very good data on the number of providers, on the number of officers. We've got reasonably good data now, thanks to the work that Lord Bellamy did in his review on the number of barristers and the impacts of the number of barristers. So it's a relatively rich data picture, all of which is public.
But I'm just wondering what's being done to pull it together and analyse it and make that available in a more digestible form so it can be scrutinised.
And of course, by the way, all that data that Jerome described, that's the data, the source for all that data is the legal aid agency that's given you these maps, which is what tells you how far in different areas people are having to travel. So that's exactly the data. Jerome's job, which he's about to tell us, is when we get all of that data, using that to inform policy. So when ministers are making decisions about policy, for example, where we might need to raise fees or what we want to do in response to certain things in criminal or civil, the data is what is informing that evidence-based policy.
What I want to move on to, I understand that bit, you're trying to put it together, but Mr. Latham, you'll be collecting a lot of data. For example, you must have data on how many cases, for example, may be delayed because of travel time by the solicitor or the barrister getting to court, as it may have to be put back in the list. You may have data as to how many people ask for a case to be stood out to get legal representation, for example, because they've not had a chance to get it beforehand. What do you do with that data?
So for each jurisdiction, there is a range of data collected. So if we took the Crown Courts, so Bob, you'd be quite right that we would collect quite detailed information relating to why a case, for instance, is vacated, why it's stood down, why it's ineffective, what the cause was for that, whether it was relating to the availability of a defence advocate, a prosecution advocate, whether there was some impediment, logistical impediment to somebody arriving at the courts at time. That can often also be the defendant as well. All that data and information is collected. We use it within HMCTS to look at prevalent reasons which are driving adjournments to see where we need to intervene to either improve things or work with different parts of the system to drive improvements. And of course, the data is available to other parts of the ministry as well when it helps in relation to forming policy.
But what happens to it with that other parts of the ministry, that's not something you deal with. Obviously, you just pass it on.
Yeah, so we have the data available, so Bob. We collect all of the data and put it into what's called a strategic data hub. The strategic data hub is then able to produce lots of different data outputs across the ministry, so it can be used for a number of reasons. So as a resource, it's available to all of the analytical teams across the ministry. It's not just housed within HMCTS and for our own purposes.
Ms. Romeo, can I just come back to you? When you referred to the maps that you've got, and the things, I think, was it yourself or Mr. Glass referred to those maps a minute ago?
Oh, well, I think we were just pointing at the maps in the...
I think you held it up for us a moment ago, that's right. The distance analysis that goes behind those maps, can we just be quite clear? That was carried out by the National Audit Office.
It's based on legal aid agency data.
Yeah. Oh, it's your data. But the National Auditors had to do the work to produce the maps, that's what I'm saying. Might it be a good idea to produce that data in exactly that sort of form yourselves? as a matter of transparency?
I mean, I don't know if we do or not already, actually.
I mean, we produce, every quarter we produce what we call a capacity review, which shows on a map all the number of providers who have contracts and where they are located.
Right. Yeah.
That is done on a quarterly basis. That may trigger some further conversations either with policy colleagues or local providers. And there is a specific forum where we sit with policy team and we actually discuss those maps and the provision of supply.
Now, you made an interesting point recently a little while ago, about in one area we'd had a major supplier had withdrawn from a contract and some of the others had capacity issues. So what do you do with the data you had? What data do you get around that? What do you do to find out why they have withdrawn, for example, what their capacity issues are, and what do you then do with that information?
Well, we gather that from conversations with their local contracts manager. So we know specifically for that particular provider, it was the inability to bill work as a result of some processing backlogs, which not the agency backlogs, incidentally, and they felt that it wasn't commercially viable for them to continue. So that sort of information.
When you say processing backlogs,
is fed
that's Home
back.
Office processing.
So this is Home Office, yeah. So this is fed through to the contract managers, and of course we feed that information back to policy colleagues, and also obviously they are in their discussion with the Home Office as well.
Do you know, did that data ever get to the Home Office, I wonder? If they're the cause of the process problems, it'd be pretty obvious that you want to join the data up, don't you? Do you have any idea about that?
I mean, I'm not.
They'll know about their own they'll know about
their own
the
backlogs.
backlogs.
Is it wise to assume
Do they
that,
know the
Mr.
consequence of
Romeo?
that?
But
Is that really wise to assume that?
But I mean, there have been a lot of meetings with the Home Office to discuss immigration provision. So we did make them aware of this issue and the general tensions in immigration. Yes.
All right. And final thing, I know that the legal aid agency monitors new cases. You try and capture the volume of work the providers take on. Got that bit. Do you collect any data on reasons why they're not taking cases on? Do you try and probe into that?
Yes,
so,
we
is it
do.
lack of demand or haven't got the capacity, or what would you do around that?
Yes,
And
we
how do you
do.
use
So,
that?
for example, I think the NEO in, I can't remember which figure it was, but they indicated, figure 10, a number of providers or officers who were not taking on legal aid work. It's figure 10.
Okay.
Actually, by our own definition, this doesn't include providers who are taking on low volumes of work.
Okay.
So those numbers look quite different
Yeah.
when you add in low volumes of work or truly the inactive officers who aren't taking on any work in any category. Now, we did a deep dive. For example, the last one we did in immigration was last year. I think 29% of the providers who we spoke to said they weren't taking on, 29% of cases they didn't take on was because of financial, because the client wasn't eligible for legal aid. And let me get the other percentage. So 29% was because they weren't eligible for legal aid. And then, let me find. The next area was they said that there was low client interest or low footfall through their office. That was 25%. And then other reasons cited were temporary issues because they were finding it difficult to recruit staff. And 13% thought that the work wasn't profitable or viable.
And is that sort of information routinely fed up to ministers?
Yes, it is. And actually it's that sort of information which was fed into policy and then up to ministers, which actually resulted in things like the Hilpers scheme. So all that intelligence that we get on the ground was fed up.
So I think the overall, perhaps to answer the overall picture question, Sir Bob, there's Jane and her team all the time are using the tactical information to do the things that they can do to ensure, to worry about exits, to make sure that they're standing up some providers to feed into another area, etc. And then there's what is longer term inevitably, which is the data being fed up to then become part of policy formulation, which is for ministers to decide on.
And if I could add as well that it's not only is it fed up to ministers, it's also published. So we published in January this year, we ran a huge survey of all of the civil legal aid providers. That is public. You can, look at the data. We had 228 organisations respond to it, and it was all. So I would say we're incredibly curious. In fact, we spend a lot of time trying to work out, as part of this civil legal aid review that we're doing, what it is exactly that's going on in the sector and how to make sure it is sustainable, because that is something we really care about.
And do you reckon we're going to see any major changes to the way we handle data within MOJ, Ms. Romeo?
Overall,
yeah.
Well, I hope so. I mean, I do. I think once again, I was going to be a bit careful about going from sort of flash to ban too quickly, but it's a huge part of what we're trying to do, partly because it's the only way actually to take money out of the system. So in the fiscal context we're in, I think we're going to have to keep automating and keep modernising in order to try and become more productive and more efficient, and a lot of that will be about better use of data. The problem we've got in large areas is the actual capturing of the data is quite hard to do. So, and we've, in a way, this conversation has evidenced that, which is when you're capturing data from so many different sources and individual firms and individual providers and individual users, you've got to do quite a lot of it in order to get something useful out of it.
You worked, I know, all of your team with Dr. Natalie Byron, for example, who's one of the leading experts in this field. She's just been asked by Justice to head up a new inquiry into the use of data in the criminal justice system. I think that was announced earlier today. Can I assume that the Ministry will be cooperating with that, and will be very happy to work with them to see what can be found from that?
Well, yes, hence the announcement. And I've got to say, we very much welcome people engaging with us on the data, and that's why we stay engaging with them, and then make announcements such as that.
Thank you.
Thank you. Just briefly,
where you talked about greater automation, greater consolidation driven by data, just coming back to a question I asked earlier, does that data include information about the relative deprivation of areas and the relative provision of broadband of areas? Because you are dealing with different people fundamentally.
It's a good question, and I mean, Jane will know a lot more about this than me, because obviously I think it's not so sophisticated. There's not a sort of data adjustment algorithm that looks at need in various areas and adjusts the data as to whether or not somebody could afford to go as far as somebody else. But I think it's broadly taken into account, probably in a more qualitative way, when Jane is having conversations with providers, because her team will know in a certain area there will be more likely to be vulnerable users, for example, than in another area. We will definitely be taking that into account. But I don't want to overstate the sophistication of that.
Where you then look at these maps and the coastal areas, for instance, massive areas of deprivation, well known within government as a whole, and yet they're the areas that often have got the furthest distances to travel, and we know they may be the least well equipped to do that remotely. I just wonder if what you're doing now is addressing a historic failure and could do better.
Well, let me let Jane say something on that, but one thing just to point out, which I know we're all well aware of already, of course, these are not directly employed. These are not staffing positions. What we're trying to do is facilitate a market. And so we've got certain levers that we can use within the context of the overall budget. That does include things like fees, again, within the context of the budget, as we're looking at via things like Claire. But there's quite a lot of areas, or, Jane can be doing tendering, or she can be ensuring, we can do things like the Civil Legal Aid Helpline, which we think is very important. But obviously, this isn't a perfect picture. So what we're trying to do is to use the levers that we have to ensure that we are maximising to support for those people who need it. And that's the whole purpose of what we do on legal aid. But, Jane might want to add on that particular question.
Just to agree with the Permanent Secretary, we don't have a limit on the number of providers who can operate in any particular area. That said, we are reliant, as I said before, on the private sector and not-for-profit areas wanting to do work in legal aid. That is the model, and provided they pass the quality threshold, then they are able to do legal aid. Rural areas, seasonal sort of demand is a particular challenge. And I think what you're actually sort of talking about here is how do we model demand in a way? And I think there's sort of three main ways. And again, Jerome might want to come in here as well. But basically, we'll forecast legal aid for spending purposes, so through a sort of financial lens, if you like. And a lot of that is based on, as I said before, what courts need, what the police need, sitting days, police officer recruitment, sort of trends in wider society, as well as historical demand for legal aid and how that is working its way through the system. So that is done regularly, monthly, in conjunction with our finance teams, and legal aid agency and policy are also involved in that process. The more local things that I talked about before, like liaison with local criminal justice boards, or liaison through our contract management resource with the various contract holders that are there, or even some local authority contacts that we have in particular areas. And then lastly, and Jerome might want to come in and say a bit more about this, and we've sort of touched on this in IMA, is all the sort of policy work that's ongoing. There's always an evaluation of how many people do we think this is going to impact on, and therefore, in IMA, do we think we have enough people in the sector to pick up this particular sort of type of work, if you like. And not least, that's really important to me from an operational perspective, because I have to sort of keep my operational wheels turning and make sure that I'm continuing to sort of process applications and pay bills in a really timely fashion as well. So it's essential that I do it for my own resourcing purposes as well as sort of for the wider market.
Thank you. I think we're going to actually straight to Sarah Owen MP.
Thank you, Chair. Ms Romeo, you said earlier on in the session that change always creates some risk, and I just wanted to ask what you're doing to mitigate, or whether you're just accepting some of those risks in the creation of the legal aid deserts that have been talked about already, particularly the risks for some of our most vulnerable people. And I'm not just talking about the geography of this, but our groups in society, particularly disabled, older people, people on low incomes, and those from the digital divide, which won't be able to access this remote service as easily. Have you just accepted that there are going to be some people that won't have access to legal aid? Is there an acceptable level for you?
One question at a time is easier, I think, Ms Romeo.
So look, the first thing to say is acknowledging risk isn't the same as accepting risk. But I think not acknowledging that there is some risk actually would be the worst thing to do, because it would mean we wouldn't be looking earnestly to mitigate those risks. We definitely don't accept them. We do seek to mitigate them. As an example, we accept that for for many people, remote legal advice is a good way of doing it. It's a reasonable way of doing it. In fact, for a lot of people, it's now the way, compared to when perhaps the legal advice market was first created, it's now the way that people expect to do a lot of their interactions. So remote access would be entirely appropriate, and things like housing and debt advice has long been provided via the civil legal aid advice telephone service. So that's fine. But we totally acknowledge that there are some people for which it's not relevant, not appropriate. And on crime, for example, we're taking forward a remote legal advice research project specifically to look at the impact of remote legal advice within the police station in order to worry about those risks that you've noted. It's going to look at which client groups remote legal advice would be appropriate for and for which it wouldn't, and also to assess potential benefits such as increased diversity in the profession, because there are some things where you've also, from the profession's point of view, you can actually bring more people into the market if it is provided remotely. But we also want to look at uptake on legal advice and levelling up in potential areas of unmet need. So we are looking all the time at doing things like that. I don't know if there's more to say on some of the specifics, Jerome.
Yeah. So, I would say the history of what we have done since LASPO is actually sort of looking at the evidence, listening to what people are saying, and then adjusting. And so let me give you a very specific example. We, as part of the post-implementation review, so all of this is set out, all the impacts on different groups are set out in sort of a lot of detail in the post-implementation review. One of the things that we did as a result of that is launch a means test review. That was specifically intended in order to make sure that we were kind of adjusting the levels of the sort of thresholds above which, below which you'd be eligible for legal aid. And we also changed quite a lot of the scope of LASPO as we've gone through in order to make sure that we are increasing or adjusting coverage to make sure that different groups are kind of covered. And so, there's a long sort of history of that I can go into, but I would say that has been the trend overall. So it's not just in terms of provision, it's also in terms of what we've been doing on LASPO.
Thank you. You talked about groups and different groups.
Yeah.
What different groups do you collect data for?
So as part of the post-implementation review, there was quite a lot of, so the PR goes into the impact of LASPO for disability, ethnicity, gender, age, I think. I don't know how many others, other kind of categories it's gone into, but certainly it looked at the impact of LASPO both in a legal help and in a representation sense across those different groups.
Was there one particular group that fared worse and that you're particularly concerned about and will focus on in the future?
So part of the issue is that it's quite, two different things, I think. So one is because of the way that LASPO worked, which was that it sort of adjusted eligibility for different types of case. So, for example, private family law. What you ended up with was it meant that different groups were caught in different ways. So let me make it very specifically. So, for example, we found that there was an increase in the number of people who were getting legal aid who were disabled. So that's from, in terms of, legal help who were disabled. We saw that there was a decrease in legal help from pre-LASPO, 71% of people who were getting legal help were white, whereas that went down to 59% post-LASPO. So, but again, it's quite difficult to untangle exactly what's kind of going on there. But it just in terms of the specific things we have done, I mean, one of the things that we have particularly adjusted all the way through was what's called the domestic violence kind of gateway, which is basically what we said was that in LASPO, private family law was excluded from the scope of legal aid with the exception of cases where there was domestic violence. Now, clearly, what has happened since 2012, firstly, you've had the Domestic Abuse Domestic Abuse Act that has broadened the definition of domestic abuse, and we've adjusted accordingly. But we've also changed, in response to feedback, the definition and the evidence requirements for to get into that domestic violence gateway. So we changed, for example, the amount of time. So it was a sort of 2-year cap, and then it became a 5-year cap on evidence. And I now think the evidence cap has been removed. So that's the adjustment that we've been making all the way through in response to feedback that we were getting.
Okay, and then I just wanted to ask, because there's been a lot of, and quite rightly so, importance put on data, I wanted to ask about the data that you collect for providers, and particularly outsourced outreach and digital providers, and what standard you're holding them to and expecting them.
In terms of equalities.
In terms of equalities, in terms of access, in terms of also satisfaction as well.
So specifically in terms of the any service that is provided remotely is subject to exactly the same sort of quality standards from the Legal Aid Agency and scrutiny as direct face-to-face cases are. I mean, just sort of specifically on telephone services and things as well, as you know, we have our civil legal advice line. Now, I mean, I think remote advice is often bemoaned, really, for certain client groups, but it can actually be, I think, incredibly helpful and play a part. So the Civil Legal Advice Line, for example, previously has got quite a lot of feedback from people who are, say, in fear of being seen going into a solicitor's office in their current locality, so they welcome the telephone service. Or, for example, it's very easy to match up with interpreter services on the telephone service or use sign language via video, etc. So all of those sort of adjustments that you would expect are in place. And actually, sorry, did you want to?
That's okay. No, I just wanted, because I've been told to pick up speed a bit. So some of these questions. So you'd say that it would be really important to have really good digital providers, particularly in areas like Cornwall, for example, that don't have as many as much local availability face-to-face?
Well, our civil legal advice line, 93% of people who use that would recommend it. And the demographics, certainly in relation to disability, are much higher than the general population and much higher than face-to-face advice as well, as are ethnically diverse backgrounds too. And that has been the case even pre-LASPO.
It's just that in our check on the ethnically diverse, do you look at language as well as ethnic diversity? You know, whether English is a second language or there's literacy?
Yes, we do, and we provide the interpreter service on the telephone.
Yeah, sorry, but when you're doing the assessment of whether it's worked, if you speak good English, and you can manage on a telephone, it might be easier than if you are from a background where your English isn't so good. So ethnicity can mask. Ethnicity on its own doesn't tell you whether someone can speak good
and
English.
all of that work will be subject to the same quality standards. So, for example, peer review by another provider from a sample of cases and things like that.
The reason why I asked this, and specifically about Cornwall, just because it's one of the ones that looks the worst on the map as well, is just that in the NAO report, looking at figure 8, which is some of the actual types of legal aid provided. So page 34, it says here, in some areas such as housing, LAA has tendered for digital and outreach only contracts where it has been unable to maintain face-to-face provision. For example, in Cornwall and parts of the Midlands, LAA does not collect reliable data on the extent to which firms are providing services remotely. So in one of the areas where you have the least access to face-to-face services, you're not collecting data for this digital outreach.
We collect all data on what is carried out in that locality.
The NAO report quite clearly says you're not collecting reliable data.
Let's just give the exact reference.
I have.
So we got it.
It's 34.
Got it.
So in those particular areas, there will be services where somebody remotely from another area provides the advice, but there is somebody in the locality that is there to help and assist the client to do that. And all of the starts in those particular areas would be recorded and reported to us in exactly the normal way as they are for the rest of say face-to-face.
Why is it that the NAO are saying that this data is not reliable? Because
sorry to interrupt you. Sorry. What I was going to say, I'm not sure that we understand the point that the NAO were making. So perhaps, because I think Jane is saying, actually, we do have data on that provision. So perhaps this is a question for the NAO.
Jenny George from the NAO, do you want to explain this?
What we were saying is that the NAA doesn't have full data on the extent to which the firms are providing the services remotely.
Yeah, so I think it's about like how the proportion of service that's being provided face-to-face versus the remote provision, not the quality.
Okay, so generally, where say for example we even have face-to-face contracts, we have amended the contracts. Part of this was during the pandemic, but even following that from providers, there was a specific request from them that it was far more efficient that they use their professional judgment to determine whether they should see a client either face-to-face or remotely. Now, we do have a provision where 50% of that should not exceed remote provision. And again, when a contract manager goes out, that will be part of their performance conversation with a provider. But you're right, in terms of a normal face-to-face contract, we do not get them to report a separate box to say, and I did, 10 were face-to-face and 5 were remote this week. We just feel that would be sort of burdensome on the provider base.
And then I think just lastly, if I may, Chair, Ms Harbottle, you talked about, particularly in the case of community care, that came out of scope and actually that there was less need. It's also one of the areas where you've got one of the lowest percentage of population within 5 kilometres to the nearest legal aid office. Is there a case that there are just fewer people requiring this, or are there just fewer people needing to accessing this?
So it is a lower volume category, community care. So we don't get as many new matter starts as we do in housing, debt, family, legal aid. The procurement areas at the time were devised around feedback from the providers in terms of they were offering more of a national service as opposed to necessarily a local service. It is quite a relatively sort of niche area of law in terms of what is within the scope.
You're looking at quality, not in that case.
So we're looking at the quality of advice rather than the quantity, which is the case in all areas.
Thank you. Thank you for now, Ms Owens. From Sarah Owen to Sarah Olney MP. I love Sarah's. Sarah's
thank you, Chair. Ms Romeo, just on the point about immigration advice, apparently, the LAA highlighted that it received 130 reports between June 2022 and January 2023 from organisations supporting asylum claimants, saying they were unable to obtain legal advice for one or some of their clients. Now, obviously, there is a major ongoing issue with dealing with a backlog of asylum cases. What analysis has the MOJ done of the extent to which an inability to access legal aid is contributing towards difficulties in clearing the asylum backlog?
Okay, well, I'll let Jerome answer that issue. I mean, of course, this is a backlog. They haven't come out the system awaiting this advice, this support yet. So the backlog that we were referring to, the backlog that we were referring to earlier is a backlog upstream of the system, for which we are responsible for providing legal aid for.
Okay, so you're saying that there's nobody who's kind of in the backlog.
I'm not saying there's nobody.
Right.
I mean, the problem is there's multiple, as it were, backlogs in the system.
Yes, I'm sure.
So the short answer, I don't know whether Jane knows the answer to the specific question in terms of the numbers of people. So the short answer is I don't think we know the extent to which people not having not being able to access legal aid would be contributing to the backlog, because I don't think that's not quite sort of how the backlog works. The backlog kind of exists and the cases are worked through. The fact that, you know, if there are a small number of cases where people don't have access to legal aid, I don't think that would necessarily add to the backlog. Clearly it's a problem though, and so hence all of the sort of remote work that we've been doing in terms of, well, trying to make sure that there is an increase in, we have a sort of what's called a detached duty advice scheme, which is basically people in immigration removal centres, for example, who are able to kind of provide advice, and all the stuff we're doing about, you know, making sure that there's payment for travel and paying for kind of additional accreditation. So we're trying to make sure that there is increased provision, but the backlog sort of is there, and the Home Office work through their backlog.
It's a processing backlog.
Are you saying that people won't be seeking legal aid until after they're no longer part of the backlog? Is that the...
Well, look, I mean, again, there's the processing of the original case.
Yes.
After that point, if their claim is denied, they may then seek legal aid to support, for example, their appeal.
Okay.
But the kind of upstream backlog is normally would be before they were seeking legal aid.
Okay, I understand.
Does that make sense?
I think so. But do you have a sense of to what extent then where people are unable to get legal aid to help with their asylum, perhaps their appeal, if that's to what extent is that adding to the issues that the Home Office are experiencing dealing with asylum cases?
It's not something that they have particularly flagged to us as something that is making the position worse, not least because the size of the backlog is relatively large, so, or in terms of, the cases that are coming through, there's quite a lot of cases coming through. So in terms of the scale, I don't think it's something that would be making a material difference. Is that...
And then just to pick up on a point that Jerome made earlier, that doesn't mean that we're not worrying very much about the fact that we know that in some areas there's a shortage of immigration and asylum caseworkers, legal aid providers, hence why we have done things like agreed to raise the fee level and the additional money for accreditation and so on. So that was deliberately to fix our bit of the market, which should both help with the IMA, but will also naturally help with other immigration work that will need to be done.
We should keep referring to the IMA, the Illegal Migration Act, just to be clear. IMA, Illegal Migration Act, just to...
I was going to go on to financial eligibility. But
I'll bring in Olivia Blake briefly.
Yeah, it's just following up on that statistic, really. I should declare an interest. I'm the co-chair of the APPG on migration, and I should refer members to my register of interest because I receive support for my work in this area from the Refugee and Migration Policy Group, RAMP. My question really is about the access issue and kind of whether or not you assess the need in an area based on like whether or not it has City of Sanctuary status, because Sheffield as a city of,
I'm sorry.
city of sanctuary status. So Sheffield as a city of sanctuary, so has a lot of people providing support to refugee and asylum seeking people. So I just wondered if that was something that was brought in, because in Sheffield we have a high number, but we only have one provider, I think, at the moment that's accessible, which seems a bit wrong.
Yeah, I mean, we are in constant dialogue with the Home Office around sort of dispersal plans and where, sort of services may be located. As I said before, we are relying on people in those areas wanting to do the service. Saying that, I've already spoken to where we see an issue, like the South West, we intervene. You talked about a charity perhaps notifying us that a service wasn't available or somebody couldn't get help. There was an instance a couple of weeks ago. We immediately made a phone call. We got that person a face-to-face appointment in their locality the very next day. So where we see an issue, we will intervene and we will try to help. And I know there's sort of in the report, the NAO raised a specific issue about immigration exceptional case funding and the difficulty or the challenge of some clients there being given a notice to say you're eligible for legal aid and then having to go around and sort of shop and try to find a provider. We completely take that on board. And although all of my staff have been at sort of soft level, helping those helping those clients to find a provider or putting them through to the civil legal advice line, we're going to take a more proactive stance, and our customer services team are going to try to match people up where that is the case and where that is reported to us, usually through charities helping people in these positions.
A very short answer. Do you agree that that is the right route for those individuals using that exceptional route?
That's a policy question.
Yeah, sorry.
It is a policy question from an operational point of view. We administer the regulations.
What's the latest number of people applying for exceptional case funding?
Well, of those, Jane will have the exact number, but last year, of those who applied, 2/3 were immigration cases. Yeah, so we are looking at that exact question, and we're about to begin some stakeholder engagement on that question. But obviously the decision to which you put something within scope for legal aid versus you have it in ECF is a policy question.
And maybe Ms Harbottle could give us an indication, that you may not be able to give the full details now, so if you want to write to us if you can't, about how long it takes your staff to process an exceptional case funding request.
Yeah. At the moment, it's 90% in 25 days. That was as of last month. It does vary from month to month.
I think my point is that's helpful to know, but also this is extra burden on your staff. So there's a knock-on cost of having a process where people have to apply for exceptional case funding that falls onto your organisation. So if there's any way you can extrapolate the costs of that time, perhaps in writing, because I suspect that you may not have those figures to hand, fine. If you're able to, without going to create new figures for us. But if you've got,
it's challenging, but I'll try.
But if there's even if it's a narrative indication, it just would be helpful to get what the knock-on effect of that is on your organisation.
And that's it for the moment.
Okay, thank you, Ms. Baker. Sarah Olney, MP.
Thank you, Chair. Mr. Romeo, financial eligibility thresholds. These have remained pretty static since 2009. Despite obviously there have been considerable wage inflation in that time. So the proportion of the population that are now eligible for legal aid has dropped considerably. Does it make you concerned that may well mean that there are people who are not eligible for legal aid who really should be, I suppose, under the what the LASPO was trying to achieve in terms of making sure people have got the representation they need?
So in May last year, we announced the means test review, which has set out our intention to implement higher thresholds. And this is going to be an injection of an additional legal aid funding of £25 million a year. So we think that an additional 2.5 million people will be brought in scope for civil legal aid, and 3.5 million additional people to fund their defence at the Magistrates' Court once we've implemented all those changes. And phase 1 of the means test review has already been implemented, which is essentially putting in the non-means test elements. So that's for things like under 18s who are seeking legal representation. And then phases 2, the remaining phases for civil and for criminal are going to come on by 2026.
Right, but you announced a review of the eligibility threshold in early 2019. It seems to have taken an awfully long time to bring this means test in. And as I understand it, it's based on 2019 data.
Well, so, 2 points on that. I mean, obviously, I agree it is a long time. It's been a really complex policy. It's involved, there's a large number, because the means test, it's not one threshold. There's multiple thresholds for different things. It's involved a huge amount of, stakeholder engagement, workshops, etc., to get to the point of May last year when we announced the means test review consultation. Well, actually, we announced the consultation in 2022. We then consulted on it. We announced the response in 2023, and that's the thing that has set the 25 million. But I think, what was it? You had a second part of your question that was...
but it's going to be based on 2019 data.
Well, we have said that we are going to review again. Before we implement, we will be reviewing again.
Will it take as long to review?
No, we're waiting. We just want to wait for some of the latest data from the ONS to take account of the latest inflation data, essentially, before we finally go nap on the thresholds, because we think that's really important and presumably lies behind your question.
Will the thresholds be continually reviewed, or is it going to take this long every time?
Well, I think our intention would be that it wouldn't take this long to review each time, but obviously it will be a matter for ministers how frequently one reviews the thresholds, partly because you don't want to be, as a statement of the obvious, you don't want to be constantly reviewing them, because you don't want people to be in scope, who would be in scope one year to be out of scope the next, or vice versa. So you don't want to be reviewing them too often. You need to have a period of certainty about them. But obviously,
it happens the other way around, doesn't it? There'd be people who are out of scope this
vice
year,
versa
will be
is the
in
more
scope next year. So
vice versa was the more
opposite
point.
Okay, but what sort of factors will you be looking at in the future? I mean, surely there's got to be a focus on these are the sorts of people and the sorts of groups that ought to be in scope for legal aid, and yet the threshold where it's set currently means that too many fall outside of it. Is that the kind of analysis you're doing when you're looking, or you will be doing, when you're looking at thresholds in the future?
Well, so thresholds, obviously, is that there's eligibility and then there's also, as you say, scope, and you essentially want to look at both. So we're still now looking at the consequences of the work that we announced in the post-implementation review of LASPO, and then there was all that work, the action plan that went alongside that. One of those things, part of that action plan was to announce the means test review. That is now about to set the new thresholds, but obviously one wouldn't want to change the thresholds again without appropriate evidence. So we want to keep that evidence gathering. We're doing a whole raft of other sort of surveys, reports to try and gather that evidence base, as we were referring to earlier.
On a continual basis.
Well, we're on a continual basis. We're gathering evidence and data now, and I think we're much better now at actually what we are doing. We're surveying providers, we're surveying users. We can say more about any of those if helpful. We've published a whole raft of reports and research on this. The question is then what you do with that in order to inform the next review of the means test. I think the absolutely key thing from our point of view is getting this one done. It's very complex digital work, putting it into the system, into all of Jane's systems to make sure it's accurate. We've already noted there's a number of competing government priorities in this space. We want to get that done, and then we will start worrying about the next time we review the thresholds.
Ms. Blake.
Thank you, Chair. I was just going to ask a little bit, if it's okay, about quality and whether you think the issues that you have with accessibility are overshadowing improving quality of services.
And, can I just ask for you to expand on the question, perhaps, in what's the quality concern that you have, in which area, or who is not getting access?
It just sounds like, you've got access is one issue. And then the other issue is the quality of that access and the quality of the advice. So, bad advice is worse than no advice. So I just wonder, and I always think there's room for improvement. And
Ms. Harbottle has teams that go in, doesn't
it?
So
exactly. But I think the point to Ms. Romeo is earlier advice would obviously, you'd hope, save money. So I was just wondering if that's there's a link between the two, really.
Well, we've got the early. I mean, you're right. I think what you're at the heart of your question is early intervention better than late intervention? And I think we think it is. And this is one of the points that came out of the post-implementation review. And we've been doing quite a lot of work and a number of pilots, which was another thing that came out of the legal support action plan, looking at specific things. I mean, essentially, the point of the legal support action plan was let's pilot some things and both use the outcome of those pilots to gather evidence. So we've got a better evidence base, but also to see what can improve the service. So in particular, we've got the early legal aid pilots, but also the now early family legal aid pilots, which are learning the lessons of the early legal aid pilots. And the point of doing those pilots is to then tell us what works and what doesn't, and what actually is improving access and what is diverting more people because in the best way, which is they're getting resolution before, for example, they have to go to court. So I think that's the work we're doing in order to improve quality.
Thank you. When we last looked at this we looked at it properly in 2015. We've looked at some since, obviously. We looked then and asked questions of the MOJ about the wider impact of not having proper legal advice at the beginning, and there was a bit of pushback from the MOJ then. What are you doing now to look at the impact on other bits of the public sector of not providing enough legal aid?
So I think the one thing that I think was probably said then, and we still think now, is it's quite hard to do precise measurements of actually what the impacts are of costs, the wider costs.
But let's have the but. I'll let you have the but.
Yes, no, nothing matters before the but. But there is, we did, as part of the post-implementation review of LASPO, we did a huge amount of work looking at essentially where people ended up in the system, and it did review the overall costs and benefits of LASPO, and that was again something, to Ms Blake's point, identified early intervention as a key focus, and since then we've launched a number of schemes to build our evidence base. We do have a lot of evidence therefore from stakeholders as to what the impact of LASPO was in terms of the changes to the scope and the eligibility, and the conversation we were just having about means test review is essentially a function of what we discovered about eligibility there. I think it is. We've also done quite a lot of work about on reports evaluating the grant schemes that we've had in place and where we think the benefits and costs have fallen on that. So I think we've done quite a lot since 2014, I think, was it when 2015 when the committee last looked at it, and most of that work was kicked off in the post-implementation review, which is a really big year-long piece of work, but there's been a lot of analysis since.
Okay, because I mean, there's also potential knock-on effects on mental health, as we highlighted, I think, at the time, and the impact of delays in going through the system because you haven't got good legal advice, which has have huge major impacts. Some of these are qualitative. It's hard to quantify for every single case going through. Are you looking at any qualitative work on this?
Yes, and I mean, Jerome will want to add to this because he's leading a lot of it, but you're exactly right, which is even when it's hard to quantify exactly what the cost is, you can normally tell when something has shunted a cost somewhere, even if you don't know what the cost is. And when that is the case, we are working very closely with the department in question, because often the cost is essentially shunted elsewhere in the system to a local authority or to a health DHSC, as you've outlined. So to work out how we can essentially move the thing further upstream or do more early intervention. And we're doing quite a lot with DLUC.
Before I bring Mr Glass in, because one of the other areas, of course, is early support for immigration cases, so that people get it at appeal stage. But we are all constituency MPs. I'm one of the top 6 customers to the Home Office as a constituency MP on immigration. Quite often people have very little hope of a case going through, but they've gone through the system and it's only at appeal stage that get any legal advice that tells them, or they come and visit, indeed, their own MP who tells them you're kind of not going to get very far with this, or indeed other cases where there are really challenging cases where they could have done with legal advice to help them shape a case that's a good case early on. And that seems to be not very cost effective. Are you talking to the Home Office about that lack of support at an early stage, which actually could be much more costly for the system as people dribble through it, sometimes with no hope, sometimes with a really straightforward case?
We are, and Jerome wants to come in, but actually the Lord Chancellor and I actually went up to see one of the Home Office case working zones to talk to them about exactly how the flow through worked and how we work together with them. I think the one thing I would say is in a world of limited resources, you obviously want to get upstream as much as possible, but sometimes when the absolute drop-dead thing you must do is deliver in the downstream, you sort of have to start there. And then
you're saying the drop-dead moment is that moment of appeal because this is whether someone stays in the country or not, and that's a critical point.
And when there's a sort of statutory requirement to provide legal aid, then that's the thing that we are spending all our time worrying about providing, well, not all of our time, most of our time. Thus, the remaining time is spent worrying about how we can intervene earlier. But sometimes in a world of constrained resources or not enough providers, you can't always do that.
But intervening earlier could be a lot cheaper for the system as a whole, if not necessarily for the MOJ.
I mean, I agree with that.
Okay. Mr. Glass, anything you want to add? And then I'll go to Bob.
Well, I think the Permanent Secretary's kind of covered it. So, it was specifically one of the things that we learnt from the post-implementation review was that we needed to put much more effort into legal advice, hence the legal support action plan. I think just 2 or 3 areas I'd point out. One of them is housing. The Permanent Secretary mentioned it. So we launched the Housing Loss Prevention Advice Service, specifically working with DLUC because of concerns that we were both seeing on the lack of legal advice in that space. We've done the housing disrepair online signposting tool again with them to try and get upstream a bit. Family law is another area. That's where we've been doing our pilots. It's where we have done the mediation voucher scheme as well. And then the other area where we've put a lot of money. Do you sometimes
look as well at where other people can get advice? So you mentioned housing, and before to go to Bob, I mean, often a councillor or sometimes an MP will pick up housing matters before they get to the legal point, because once it's lawyer to lawyer, it's an impossibility for an elected representative, for example, to take up the lawyers won't speak to you either way. It's much more expensive, and it doesn't always, and sometimes it will be in the most egregious case. Sometimes for instance, a local councillor can get as good a result much quicker and cheaper. Do you look at those options?
Yeah, so absolutely. I mean, one of the biggest one of the concerns we have is that, and this is true in housing and it's also true in family law, is that, a concern that cases are getting, either to court or they're not being resolved adequately because people are just, not aware of how to navigate the system. And it is a very complex system, whether it's immigration, whether it's housing, whether it's family law. It's a very complex and intimidating system, particularly for vulnerable people. And so that is precisely why we're putting that effort into upstream legal advice. As you say, when it gets to the point where it's in court and so on, it has momentum of its own.
And with court delays, it takes quite a long time to come through too. Okay, so Bob.
Thanks.
Thank you.
One thing I think that is probably common ground is that whatever on the merits of the policy, not your concern, but as a matter of fact, LASPO has led to an increase in litigants in person in virtually all jurisdictions. I'm just interested in what the Ministry is doing and its agencies are doing, again, to capture as much information as you can about the extent of that, both in numbers and also about the potential costs on the rest of the system. So what do you do, for example, to track how much longer, with hard evidence, litigants in person take in the various jurisdictions, crime, civil, family? We've heard evidence, I think you've probably seen evidence given to us by senior judges about it. But what's being done by the Ministry and its agencies to get a firm statistical handle on that?
Well, so we've got quite a lot of good data on this, and the spoiler is it doesn't always take longer. But I'm going to hand over to Jason, having stolen his key top line.
Mr. Latham.
So Bob, looking at different jurisdictions, it looks different. If you're in tribunals, for instance, there is a part of the justice system which has pretty much been established to deal with litigants in person in terms of its systems, its processes. If we look at private family law, for instance, which we know that since the legal aid changes, that the number of litigants in person has significantly increased over the last 10 years. If you look at the impact on waiting times, where both parties do not have a representative, it tends to take slightly less time than it does where both parties do have a representative. That was a feature pre-LASPO, and it's continued to be a feature. It's about a 2.5 week difference in terms of whether how long cases take to go through the system. So when you look at the data over quite a lengthy period, litigants in person in the private family law space haven't specifically taken longer to get a result out of the system. In fact, it takes slightly longer where you are represented. If you then start to look at durations of hearings, durations of cases, it's true to say that hearing durations have increased for litigants in person, but that's against a kind of broad trend of hearing times have increased for all parties in the family courts. So even where the parties have legal representation, their hearings are taking longer. There's not really much difference between the duration of a hearing for a litigant in person, where both parties are unrepresented, against a case where both parties are represented. One of the kind of big trends that you can see over the last 10 years is the shorter hearings, 30-minute hearings, for instance, has significantly decreased, but this is across the board, and longer hearings of at least 60 minutes have significantly increased over that time. And so that's why you see a broad increase in hearing durations in private family law proceedings, but not necessarily in terms of the waiting times for different people to move through the system.
Well, that's taken private family law. Public family law rather different, isn't it?
So in terms of levels of representation in public family law, of course, it is...
Generally, you'll have better people, but what about it?
Yes, you will have lawyers. And so,
generally, but equally, in a lot of county court proceedings...
Yes, so it depends which part of the county court you're in.
Let's take money claims or and so.
Money claims, levels of representation, I think have historically been somewhere around about 30%. It generally depends on the value of the claim.
Possession?
So, sorry?
Yeah, okay, value of the claim, that will make a difference. More
yes,
claim,
the value of the
claim
makes a huge difference. So if we look at claims beneath the value of £10,000, I mean, that's very much a part of the civil system which has been specifically designed for litigants in
for that
person.
anyway, would you, in reality, because it's probably not worth it?
No, in personal experience, no. Those have been specifically designed to enable a litigant in person to make a good case. It's one of the reasons, and I know Jerome may want to come in here, that we're introducing automatic referral to mediation for small claims in May.
Before Mr. Glass comes in, what about housing, for example?
In terms of possession cases?
Yep. Possession cases, yes, and related debt cases.
I haven't got the information directly to hand on possession. What I can say is what tends to happen is... if you look at a county court process, lots of cases are listed. It's generally the engagement levels of the individual litigants, that is the issue. Not very many litigants will come to the court in relation to their case.
Do you capture any data, any data at all, or try to, as to any differential between representation and non-representation of cases that settle, which then save a court hearing?
In terms of the county court?
Yeah, because it'll be recorded. Somebody will go into court and say, look, or they withdraw the claim or say it's settled one way or another, either by letting the court know remotely and they can vacate the hearing, or perhaps the parties turn up and say we've come to an agreement and we want here's the agreed judgment we want.
So it's not a piece of information I have directly to hand. We do collect information on who's represented and who's settled.
With the best information you can provide.
I just wondered, when you talk to the judiciary,
yes.
did you run your analysis past the judiciary, for example, in the individual courts, or at a senior level, for example, with the judicial office or the ministry on your behalf?
The analysis of
the impact that litigants in person have upon court hearings.
So I wasn't suggesting for a moment that there are not significant challenges for litigants in person, and that over the last decade the judges have put significant effort into how they operate when litigants in person. We can see that through the Equal Treatment Bench book, the huge guidance that's out there, so yes, they have an impact I don't dispute the qualitative impact if you're a district judge or a deputy district judge day in, day out. But when you look at the quantitative data, unfortunately, the case doesn't come out that if you're unrepresented, it takes you longer to move through the system.
Well, one quantitative bit of data we do have, of course, is the difficulty that's been had in the shortfalls in the district judge and deputy judge recruitment competitions recently. Seems to suggest it's hard to recruit people to sit on the district bench. The conclusion that's been put to the Justice Committee is one of the reasons for that is the extra burdens that the increase in litigant in person places upon the judges having to try the case and having to try deal with people without any legal expertise. I mean, for example, one judge telling me, I have to, in the family, more than one judge saying, I end up having to do the photocopying. I end up having to try to get the papers in order to ensure that that is a fair trial. That's a burden on the system, isn't it, that so far there doesn't seem to be a measure of capturing.
I mean, I would agree, Sir Bob. I mean, operationally, it's a rare day where there's an expectation that judges are left to photocopy their own papers. That is certainly the responsibilities of the court staff.
It certainly ought to be, but there's indication sometimes the pressures get so bad.
It might be worth just briefly, Chair, if I may, adding that, of course, we have injected quite a lot of financial investment into supporting litigants in person. So since 2019, we've injected £23 million via a number of different grants, particularly to support litigants in person, accepting that they do need more support.
Got that. Two quick points, if I may. Is there any work that you do to find out from other government departments, for example, any evidence that they have as to the impact of litigants in person? For example, any additional costs that are incurred by, let's say, health authorities on NHS litigation or local authorities as parties to proceedings, which may or may not take longer, or where it may take longer to come to a settlement than might otherwise have been the case. Is there any means of why that's
I don't think other departments routinely collect that information, so I don't.
Okay,
I think.
Do you know any anecdotal or quality, information?
No, though obviously that is part of the reason why the Treasury has funded us the 23 million, because they acknowledge that it's a problem that is worth trying to fix.
Yeah. And then finally we had that attempt at a pilot for early legal advice, about 5 million in 2019. That really didn't take off at all, did it? We think got was it three providers against 1,600 target. What's the lessons to be learned from that, do you think?
Well, I mean, others will want to add. I mean, the first thing to say is it is. Obviously, it's not great to be doing a pilot and then having it, we acknowledge really quite limited take-up. On the other hand, actually, sometimes you can't always do the pilot that then suddenly is the huge success, right? So we did a massive amount of, we were focused in two areas, Manchester and Middlesbrough. We did a big push to try and encourage take-up. We had a certain number of people look like they might be interested, and then we only had 3 who were. I think one of the lessons isn't from the amount of effort that was put in to try and make a success of the pilot. It was just that the way we'd sort of targeted it and what we were offering ended up not actually being appealing. I mean, I don't know if there's anything else.
Jane, not from an agency point of view, but
so two things quickly. So the first is, as the Permanent Secretary said, we've learnt a lot actually from it, and we failed fast in the sense that we sort of stopped when we saw that it wasn't getting the take-up, and we then used that learning to design the next thing that we are doing, which is the early family legal advice. 2 things that we learned. One of them is better engagement with the providers. I think we were a little bit top-down, and so we're going to do that better. And then the second is, rather than write letters to people, work with the providers, existing providers, their clients. The second is just better comms and advertising, actually, just generally across the piece. One of the issues that we've been finding as we've been doing the review of civil legal aid is just people just don't know that they are eligible, and they think legal aid is for crime, and are not aware of the legal aid is available in lots of civil cases as well. And so we are, that's something we've really got to work on.
In the spirit of our ambition always to collect data, we are doing a full evaluation actually of it that we're going to be publishing later this year.
Well, I have to say 2 words that make us happy: failing fast and evaluation. So you get a little gold star
a little high
in the mix.
Try to do it before the next election. I can afford to really get it.
But rather than doggedly going on with something that's not working, it's better to acknowledge. So we acknowledge that.
Thanks.
Okay, thank you, Sarah Olney, MP.
Mr. Latham, I've got a bit of a concern. You talk about the private family law and the impact of litigants in person. One of the things that concerns me, if you've got one party that is properly represented and another party that is a litigant in person, is there a risk that, say, for example, child protection concerns or perhaps domestic abuse allegations, can they be properly tested when there is that imbalance in legal representation? Is that a risk? Is that something you're aware of? And if so, what might be done to mitigate that?
I mean, to start off with, in terms of the what does that look like in terms of waiting times? So broadly, before I talked about the waiting times where either both parties are represented or not.
In the court hearing, you've got one party who are represented, and one party who are not. I'm concerned that if it is, for example, a child custody dispute, if there are concerns being brought forward about child protection, can they be properly tested if one party is unrepresented and the other isn't?
I mean, yes. I mean, if you look at the judicial model in private family law proceedings is always to start from the interest of the welfare of the child. The court has a wider duty when there is a litigant in person, one of safeguarding and protection. I would say yes, whether one party or the other is represented, the court won't. That doesn't diminish the way that the court will investigate the issues at dispute. Generally, what we tend to see is where the respondent party is solely represented, those cases take considerably longer. In fact, they're the longest cases to go through. Where it's simply the applicant who's represented, those tend to go through in the shortest amount of time. But in terms of whether it places the litigant in person unequal in arms, I don't think so, no. And there's been a huge amount of work put in place by the judges to ensure it doesn't happen.
Mazon, if I could just add, sorry, because it's an important point. Where there is an allegation of or a risk of domestic abuse in a private family law proceeding, that in that case there should be access to legal aid, and that is something that's specifically sort of set out in LASPO. So I'm not saying it doesn't happen, but I just think that concern, I would hope, would be addressed through that exemption.
That's good to know, thank you. There are different types of litigants in person. There are some who are very actively involved in their case and they will turn up, argue in person. There are others who will simply just not engage. Are you distinguishing perhaps between those two different types, and how does the data reflect that difference?
So this is really where the limitations of the data find their cul-de-sac. I mean, we're really talking about active and inactive parties, and it's much harder to define that and to collect data on it. So one of the anecdotal instances that's often relayed about the private family court is returner applications, where somebody's returning with an application that's been heard previously by the court. And so one party is tremendously engaged because it's almost relitigating what it's brought before, and the other party is less engaged because it's been through it all before, it's been through the mill. And I think, as we've acknowledged, particularly in the family court, these are particularly stressful and anxious proceedings for all involved. So I would not say no, there isn't a level of that, but does our data get to that? No, it doesn't at the moment. It's quite limited in terms of what it can capture.
Presumably then there's a risk, given you've got these two perhaps different types of litigant in person. Type 1, if you like, their hearings are going to take longer than type 2, but you're rolling them all together. So do you think you're getting an accurate picture of sort of an estimated hearing time? In terms of, you've got these two different types and one will take longer than the other, but if you're not distinguishing between the two types, but you're coming up with one sort of estimate for how long a hearing is going to take, when you've actually got quite a wide sort of span of different types of hearing, then do you think that your estimated length of hearing is going to be impacted by the fact that you're not distinguishing between these two types?
So I think that was really behind the point which I didn't articulate particularly clearly, where I was pointing towards the trend we see with the respondent party, where one is they're legally represented but the other side isn't. Those proceedings tend to take considerably longer in terms of waiting times, generally because that is where we see a very active unrepresented party. When we look at just the applicant only, that's why they take the shortest amount of time, because you tend to find there a more inactive respondent in relation to the application. But really the data that we collect currently isn't really able to distinguish what are fine categories. As we start to roll out the digital service that we're currently piloting in this area, this is exactly the kind of data that we do want to be able to collect, because it will tell us about returner applications, about the different characteristics of people bringing the applications. That will give us far more insights for an operational purpose, but also in terms of the ministry, capacity in terms of legal aid, but also for Jerome in terms of what are the right policy options to craft at the right time.
Thank you.
Thanks very much. Sarah and MP.
Thank you, Chair. Looking at the failure to increase legal aided mediation in family cases, I know that there was a lot of work done in that, and there was a consultation which reported back in January this year. What was the reason given for that failure to increase legally aided mediation in family cases?
So, of course, if you look at mediation overall, the numbers have gone up significantly because of the voucher scheme, the family mediation voucher scheme. So you're right that following LASPO, numbers dropped significantly. So in 2012-13, the number of publicly funded mediation cases were about 13,500. The following year it was 8,500. But because of the introduction of the voucher scheme, the number last year was 17,250. So it's actually gone, we've sort of plugged the market. It's still publicly funded mediation. It's just we're doing it by vouchers rather than by access to legal aid.
Was there a reason why it is that people are choosing to use the vouchers? Because there is a small proportion of people that were eligible for legal aid but actually have chosen to use the vouchers instead.
Yeah, so, I mean, essentially what was happening prior to LASPO was that solicitors, people were going to, because the position prior to LASPO was that private family law was in scope, so people were going to their solicitor and the solicitor was referring them to mediation. And so when they were no longer going to the solicitor, we thought at the time that people would spontaneously be going to mediation. That, you know, it turned out to not be a correct assumption. And so what we have done is plugged, as the Permanent Secretary said, try to plug the market. But I mean, clearly that was, and it's, you know, set out in the report and set out in your previous report, that was a mistake that was made at the time in terms of the assumption.
Okay, thank you. So moving on to the sustainability of the legal aid market, Ms. Romeo or Jerome Glass, why has it taken so long to review the criminal and civil legal aid fees?
Well, I mean, we have injected obviously quite a lot of money into the process. So we had we first injected the 23 million in the Advocates Fee Scheme reform, which was in 2018. We've injected 51 million via CLAR, which was the Criminal Legal Aid Review, which of course then became the Criminal Legal Aid Independent Review with the Bellamy report. And as a result of the Bellamy report, we will be injecting up to £141 million in steady state. So there's been a sort of process that has culminated in Clare. That's the Criminal Legal Aid Independent Review. On the civil side, ROCLA, see what we did there, Review of Civil Legal Aid, you know, we like an acronym, which was launched in January last year, and we will be finishing the evidence building phase in about May this year, and we're working towards a green paper in July. And what we're determined to do throughout all this, and see earlier part of this conversation, is to get the evidence before we actually come up with the changes. So that, I mean, the civil legal aid side has taken quite a long time. Doesn't mean we haven't done quite a lot in the meantime in terms of trying to respond to particular things. The housing loss provision, I can never remember Hill Pass is the acronym. Doing things like that, which is an injection of £10 million. That's an example of something we've done in the interim while we're waiting for the full outcome of the civil legal aid review.
Thank you. So I appreciate that you probably won't want to share the answer to this question just yet, but I'll kick myself if I don't ask. So do you expect to raise civil legal aid fees following the review, or are you going to see more work, interim works and support?
So I don't think it'd be right to noting you'd ask the question. I don't think I can answer the question.
Okay, that's fine.
So when is the green paper? Just on timetable. When's the green paper?
July.
And in terms of saying that this has actually taken quite a long period of time in comparison, what's the hold up and what's causing the delays and the length of time for this review?
Or the civil legal aid review? Yeah. Well, I actually think, so it got, having been kicked off, it just took a lot of time to do all the evidence gathering and all the kind of workshops and so on to get the data. So we're still be in the evidence building phase. It's just taken a lot of time to gather all the evidence. And then to get to the green paper, I think overall it will have been about 1.5 years, which is quite a long time, although less long actually than Claire took from flash to bang. But anything to add on that?
No, well, in a way though, I know it feels like a long time if you're a provider, and we completely understand that. What we don't apologise for though is getting the evidence in order to, and then making the policy off the back of the evidence. And we've done extensive analysis with international comparators coming. There's economic analysis. There's surveys of the market. We've been working with the Law Society. They've done their own surveys of profitability, so that we design a policy. You know, one of the critiques last time around of LASPO was that it was done in a little bit of a rush. We're making sure that, we're trying to learn the lessons of that and make sure that we design the response to the civil legal aid review that's really evidence-based, and that the providers are really bought into.
No, I appreciate that, but I just want to have one more go at this. In terms of the evidence gathering, is it the scale and the volume of the evidence that you're trying to collect, or is it the resources and in terms of staff and funding that's causing a bit of this delay, or is it a little from column A and a little from column B?
I think probably quite a lot from column A and a little from column B.
Okay.
But we've done a number. I mean, Jerome already mentioned that there's already been a lot of the data that we have collected. We've already put out there in terms of provider data. We've also got the legal problems and resolution survey, which is surveying 10,000 potential users. So there's a whole lot, things like those surveys, in order to get, if you're trying to survey 10,000 people, it's obviously going to take quite a long time if you want it to be rich data. You've got to work out who the 10,000 are, and they're selected in a particular way to make sure they're representative. So I think a lot of it has been that. And obviously we've got a number of other priorities that means we don't have sort of infinite amount of resource to put on it.
Okay. Thank you very much. Sir Bob Neal.
Well, just quickly going back to Bellamy, one of the recommendations of Bellamy was that going forward there shall be a mechanism for potentially uprating on an annualised basis rather than the it's like cliff edges that they've had in the past. What's the progress on establishing that?
Well, so you'll know that one of the recommendations was the Criminal Legal Aid Advisory Board, which is essentially looking at the sort of future structure and levels of fees. So that will all be captured under that, and that's already underway. It's meeting, it's being chaired by a judge, and it will be it'll be advising and giving recommendations to ministers on things like levels of fees and structure of the fee system.
Mechanisms remain within scope of their work.
Yes, I mean within scope of that. I mean obviously they're an advisory board ultimately, but yes, they'll be.
They're not
looking
precluded
at that as well.
from suggesting here's a means by which you can update it.
No, we hope. I mean, we hope they will.
You'd like they would. Yeah,
yes.
You hope that they would. Yeah, because there has been some concern in the sector that there might be some rowing back on that, but not as far as you're concerned.
I don't think so. I mean, that board is set up in order to come up with thoughts about, appropriate levels of fees, but also structures, because as we've discussed before in another room in this building, the where you pay the fees and how the incentives work is a crucial part of it. So they'll be looking at that as well.
That's very helpful. And the other thing I was going to ask on the civil side, maybe you could pick up on this, Mr. Glass, as well, is you'll have seen our committee, Justice Committee, have lots of evidence about the age of duty solicitors in particular. And we talked earlier about gaps, geographic gaps in the scheme. I think the suggestion is, isn't it, average legal age, average duty solicitor is about 47, sometimes even worse in some parts of the country. What's the Ministry doing proactively to try and improve the supply? That's really making it more attractive to young people who, frankly, at the moment, it's not worth their while to turn out at 2 o'clock in the morning on the levels that they're getting. What can be done on the basis of what you've got to improve that?
Two things.
You might say more money, but these are other things as well.
Well, quite. So the first thing is also just to add to what the Permanent Secretary said on the Criminal Legal Aid Advisory Board. One of the things specifically it's looking at is the structure of the litigators' graduated fee scheme, and that's one of the areas where we really said we need you to help us design something that's better. Sorry, I think you said civil. Do you mean criminal duty schemes? Yeah, so duty solicitors. I mean, and Jane might want to come in specifically on the sort of age profile, but we again. I know you said not just fees, but we are very specifically consulting right now to increase fees for the police station scheme because, and I was with a provider last week who was saying what they do is they find it really hard. This was a provider in South London who was saying we find it really hard because people, young people coming into the firm, we're not able to pay them an appropriate amount in order for them to be able to to live here and so on. So we're live to that kind of risk, and so hence why we're trying to put more money into the front end, the sort of police station end of the scheme.
Finally, Jane, if I may just come to you on a broader thing, and that's, there's been quite a bit of evidence that the contract period is roughly 3 years normally. That's the average. Are you looking at whether or not that may be a problem sometimes? Because a firm wants to expand, and at the moment they're not in a position to do so, or is there scope for some flexibility to enable people who actually do want to expand, maybe actually do want to do some crime or some immigration law somewhere where they're not, to actually start part way through, or would having to wait for
you're
year?
Absolutely right. So historically, I think this is probably the biggest barrier in terms of entering the market. So we've gone out with a tender for 3 to 5 years. Surprise, surprise, we've got an uptick in the number of providers. We've allowed people to leave, but we haven't allowed anybody to join. So by the end of the period, which are inevitably sometimes extended, we have less providers than we do at the start. So that is something absolutely that we're committed to doing, and we'll be consulting with representative bodies shortly. So first time ever, we opened the civil tender midterm last year, as I said, and we got a good response to that. Contract for crime from September 25 is in development now, and we will go out to representative bodies with a number of measures, not just about the term, but also about a number of other things that might ease, I suppose, the administrative burden of doing business with us. And that's absolutely a commitment and a goal for the agency and my board as well.
Well, that's welcome.
Good, thank you.
Thank you very much. Sarah Olney, MP.
Thank you very much, Chair. The NEO report found that there were weaknesses in the MOJ's data and processes, which mean that there are risks to ensuring the sustainability of provision of civil and criminal legal aid, that not enough sort of horizon scanning to anticipate issues that might arise, and you're not collecting the data you need to ensure that the kind of firms and organisations that are currently providing legal aid services, whether they're going to want to or be able to continue to do so in the future. Mr. Romeo, can you tell us what sort of actions you might be taking to kind of address some of those issues?
So, obviously, in a way, everything that we've been describing in this session leads towards that. So there's the work that is being done on an ongoing basis at a regional level by Jane and her team, which is, who's planning to exit the market, where are we going to have problems. That's essentially at the core of market sustainability. But then there's the national picture, where we're gathering information we gathered a lot of information via the Criminal Legal Aid Independent Review, but also, and now the board, CLARB, will be essentially doing ongoing work on that, and they'll have anecdotal but also some survey data to inform them. But then all the work that we're doing on civil legal aid that's going into the review of civil legal aid, that's essentially going to be telling us the position and informing us the view of market sustainability on the civil side, and that will be informing the actions we need to take in order to meet that sustainability and ensure that there is a sustainable market.
And are there current challenges that are coming up through those processes that you think you need to urgently tackle in order to maintain market sustainability?
Well, some of them we've already been tackling. So housing was a good example where the housing lost possession service and the injection of the £10 million, that was a good example of somewhere where we knew there was a particular problem in housing. We didn't want to wait for the green paper, so we already launched that in 2023, last year. So there are areas where, immigration is another area where we know the fact of the Illegal Migration Act is going to put an additional pressure on. So in advance of that, we did the policy work to say, right, we've got to uplift the fees. We're going to make additional payments for on the duty advice scheme. There were kind of other areas like that where when we know something's going to be a problem because it's coming out of the evidence we're gathering, we're not waiting, we're sort of putting targeted interventions in to address those particular issues, but we expect when the review of civil legal aid is concluded that there will be, particular additional things that we'll want to be doing, but that will come out in the green paper.
And are you finding a sufficient pipeline of properly qualified practitioners, or is that an issue that's on your radar?
Well, it's definitely an issue because one of the things is we want to make it easier. It's all about reducing barriers to entry to the market, right? So we want to make it easier, for example, for Silex practitioners to qualify to be solicitors. And there's a raft of work we're doing and as part of the review of civil legal aid, we're looking to do that. And we do review solicitor advocate and barrister data through the Criminal Legal Aid Advisory Board, aforementioned, which is going to help ensure that we're monitoring practitioner levels across those areas. And getting the barriers down so we can bring more people into the profession is essential. I should say we work incredibly closely with the profession because what we see our role as being, what it is to facilitate those people for whom, they work incredibly hard in order to provide this crucial service for the citizen. So we're really very keen to ensure we're making it as easy as possible for those who do want to provide services to enter the market.
Thank you.
Thank you very much indeed. Can I thank our witnesses very much indeed for their time. It does feel a bit like Groundhog Day. It feels like not that long ago since we were looking at the implementation of this. So lots for us to get our hooks into to follow up on, I think, as this goes through, and not least the Green Paper and so on, and various bits of legislation coming in. But the transcript of this session will be available on the website uncorrected in the next couple of days. We'll be producing a report. It will be after the Easter recess. But thank you for your time, Jane Harbottle, Antonia, Romeo, Jerome Glass, and Jason Latham. Thank you very much indeed. Order.
The proceeding has ended. 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 The proceeding has ended.